Hello, everyone. I'm quickly going to take you through the tort of trespass to goods or chattels. Um, essentially walk you through what constitutes trespass to goods, the different elements that need to be present for one to successfully found an action in trespass to goods, how trespass to goods relates to the torts of conversion and the tort of detinue, the difference between the tort of conversion and the tort of detinue, as well as the overall defenses available in regard to an action relating to trespass to goods. Trespass to goods or chattels is defined as the direct and wrongful interference with goods in the possession of another person. This tort essentially provides protection for the person entitled to immediate possession of the goods or the chattels in question. It protects people's rights to possess personal property free of any wrongful interference. When we talk about interference in regard to trespass to goods or chattels, that interference may be manifested through many forms, and these include taking the goods or chattels from another, damaging the goods, moving the goods from one place to another, or even simply touching the goods. Trespass to goods, like other forms of trespass, is actionable per se. That means that there is no need to prove damage. Any interference with the goods constitutes a wrong, whether there has been damage or not. Trespass to goods is absolute, and this means that a person may be liable, notwithstanding that he is acting or he acted in good faith and was not aware or is not aware that his actions are wrong. In this regard, you can look at the case of Kirk versus Gregory, where it was stated that any form of deliberate destruction of the goods could amount to trespass. But even using the goods without permission constitutes trespass, and it's no defense, for the defendant to claim honest but mistaken belief that the goods belonged to him. It is very important to note that trespass to goods is based on interference with possession and not interference with title. Accordingly, a person in possession of the goods or the chattel may maintain an action in trespass against all persons except a person with a better title. The critical element that needs to be present for one to sustain an action in trespass to goods are as follows. The person founding an action in trespass to goods must have been in lawful possession, and that means actual or constructive possession at the time of the interference. This person does not need, however, as I've already said, to prove a title to the goods or to the chattel. All the person needs to prove is that he or she had actual or constructive possession of the goods at the time of the defendant's act. The second element that needs to be present relates to the interference, which in this case has to be a direct consequence of the defendant's act. This interference could be as simple as simply touching someone else's goods without authority or consent. It's important, again, as I've already said, to note that there is no need to prove actual or material damage. The third aspect is that the claimant needs to establish that the defendant was at fault by interfering with the goods or the chattel. Liability may be vitiated if it's established that the interference was not intentional and probably the defendant was not negligent. Trespass to goods has some elements and features that are similar to or overlap with the tort of detinue and the tort of conversion. In practice, if a party is founding an action under this particular tort, they would need to sue for all the three torts because they are too interconnected. They would need to sue jointly for trespass to goods, conversion, and detinue, and then hope that probably they could be successful in at least one of them. Conversion is defined as the act of intentional handling of goods that is against or inconsistent with the will of the owner. This could be through withholding, misusing, misdelivering, or changing the nature of the goods, or it could ultimately be an action that is so significantly inconsistent with the owner's right to possession of the goods that actually attempts to wrongfully deprive the owner of the right to possession. Essentially, conversion is the wrongful assertion of title to goods or the wrongful denial of another's title to the goods or the chattel. The essence of the tort is that the defendant has done something inconsistent with the title or the right of the owner. I invite you to look at the cases of Wilson versus Lombard and the case of Folds versus Willoughby, which discuss trespass as well as conversion. These cases are on your reading list. For the sake of clarity, I just wish to give you examples of acts that would constitute conversion. And these include, and by the way, this list is by no means exhaustive, but it includes contradicting the title of the true owner, destruction of goods belonging to the claimant, or intentionally risking the confiscation of or destruction of the goods, selling the goods without the claimant's permission, receiving goods which have been obtained by fraud and selling them in good faith to someone else, misdelivering the goods, and simply taking the goods. All the above acts are manifestation or examples of conversion. Let me also quickly take you through the tort of detinue. And detinue is the wrongful withholding or detention of goods by the defendant, in respect of which the defendant has a better title. The person detaining the chattel must do so adversely to the claimant's rights. In many cases, detinue is classified within conversion, as the two only differ in the sense that the act complained of is considered detinue and not conversion when the owner specifically asks for the goods or chattel or property back, and then the defendant refuses. So there has to be an element of demand from the owner of the goods before you can found an action in detinue. The tort of detinue is therefore committed by the wrongful refusal to return the goods to the plaintiff on demand. And detinue is therefore not committed by the defendant until the demand for the goods has been made by the plaintiff and the defendant has refused to surrender the goods. Let's take the example of a person who finds a chattel, a lost item, and is not aware of the identity of the true owner. This person may retain possession of that good, chattel, or item against all parties except the true owner. The true owner with a better title should first then demand the return of the chattel before the plaintiff can consider to take action founded on the tort of detinue. And for the action to succeed, the demand for the chattel must be clear and precise. It must specify the following, among others. 1, the description of the chattel. 2, a clear demand. It must constitute a clear demand. And 3, it must specify the time, date, and place of the delivery of the said goods or chattel. In relation to detinue, it's critical to also discuss what is called the finder principle under trespass to goods. The critical question is, does a finder of an object, a person who picks a lost item, have a right of ownership that the court will recognize against someone other than the rightful owner? To this end, I invite you to look at the case of Amory versus Delanry. And in that case, the plaintiff, who was a chimney sweep boy, found a jewel and took it to the defendant's jewel shop, where he showed the jewel to an apprentice to find out what it was worth. Upon hearing that the jewel was worth 3.5 pence, which was too low according to the plaintiff, he decided that he wanted his jewel back, and the defendant refused to return the jewel, and that was why the case ends up in court. And in hearing this case, the court established the following legal principle. A finder of an object has a property interest which is not absolute, but is sufficient to allow the finder to keep the object against all claims but those made by the owner. In other words, if you pick an item, a lost and found item, you keep it as the finder, and you'll have temporarily, in quotes, a good title until the actual owner shows up and requests for it. If the actual owner does not show up, then you have a right to keep that chattel property or good. Let me take you through some of the defenses that are available in relation to the tort of trespass to goods. The first one relates to consent. If the owner of the goods consented with the interference, then they shouldn't be able to succeed in an action against you. They can only succeed if you exceeded the consent that was given. And in that case, if the terms of the consent are exceeded, then the consent would be negated. The second defense relates to statutory authority, and essentially here we're talking about lawful authority. The law, you know that the law gives, for example, the police or even public officers powers to enter property, search and seize goods. And also a court may issue an order directing the police or certain public officials to enter, search and seize property and even dispose of property. So if there is a statutory authority that's backing up what would be a trespass, then that defense is available, and then the action for trespass to goods would not succeed. Other defenses relate to necessity. I had to do this. Inevitable accident, there was nothing I could have done to avoid this. Possible defenses around mistake. If your actions were not deliberate or negligent, as well as a possible defense of retaking. If I am trying to take what actually belongs to me and I'm sued for trespass, then I can argue that actually I'm just taking what ordinarily belongs to me. I thank you for listening to me.